case briefs, and so much more. LSData's got what you're looking for.
In a country that fiercely protects free speech under the First Amendment, the Supreme Court heard the case of Beauharnais v. Illinois in 1952 to explore its potential limits. The defendant was convicted for making incendiary statements that stirred racial and religious discord. His conviction has now given cause for the Supreme Court to evaluate: is the 14th Amendment's Due Process Clause a shield against state sanctions for disseminating defamatory remarks about specific groups? Joseph Beauharnais, the petitioner, found himself arraigned in the Municipal Court of Chicago and confronted with a $200 fine for breaching a section of the Illinois Criminal Code. This legislation specifically prohibits the public exhibition or dissemination of materials that could expose certain classes of citizens, differentiated by their race, color, creed, or religion, to derision or contempt. Beauharnais fervently argued that this state statute infringed upon his freedom of speech and press, as safeguarded by the 14th Amendment. Undeterred, he also contended that the edict was too vague to validate his conviction. Ultimately, the Illinois courts dismissed Beauharnais's arguments, leaving his conviction intact. With the significant constitutional questions left unanswered, the Supreme Court agreed to undertake the case to clarify the boundaries on a state's authority. That is, whether a state has the power to penalize speech that incites animosity among disparate racial and religious groups. The Supreme Court concluded that the lower court had misstepped in declining a requested instruction. The operative legislation, a criminal libel law, tasked the trial court with determining the libelous nature of utterances while assigning the matter of publication to the jury's discretion. This approach remained congruent with the established protocols for prosecuting libel cases in Illinois. The Supreme Court acknowledged Illinois' power to enact the law, regarding it as not unconstitutional. However, it clarified that its decision did not signify endorsement of the wisdom or efficacy of this legislation.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.